All right, good morning, everyone.
Morning.
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 Mr. Schwartz, when you hear me?
Yes, I can, Your Honor.
Okay. Let me go ahead and mention, are you all able to see the clock in the corner?
Yes.
Yes.
Okay, so one of our staff people will be keeping track of the clock. These oral arguments are being streamed so the public can view them. Of course, we're the only ones on Zoom. Let me go ahead and introduce you to the other members of the panel. I have Judge Orfinger and Judge Lambert. I'm Kerry Evander. Each will have 20 minutes aside for oral argument. How much time does the appellant wish to reserve for rebuttal?
7 minutes, Your Honor.
Okay, I'll try to help in that regard, but you also do have the clock there. We'll go ahead and give it another minute or so we don't start too early. Have you all done Zoom before
Yes, Your Honor.
A few times now, yeah.
with hearings? Okay. All right, Mr. Schwartz, if you want to go ahead and proceed.
May it please the court, Steve Schwartz for Security First. This case should not have gone to the jury with the instructions it did. The concurrent cause instruction that was given to this jury not only misstated, but ignored this insurance policy's anti-concurrent causation exclusions. Therefore, the jury was told the wrong law governing its decisions and asked the wrong questions. To be clear, this was not a so-called SIBO case. This was not an insurance policy that only had concurrent causation provisions. This policy, its water damage exclusion, was part of the anti-concurrent preamble of this insurance policy. So there was no coverage for windswept rain, no coverage for roof or interior water damage, unless there was proof that the roof or the interior damage being claimed was due to a covered peril. Here, the only covered peril offered was wind, and that covered peril of wind created an opening in the building through which the rain came into the building and caused the exact damage being complained of. Because of the anti-concurrent policy exclusion, if some part of the damage was excluded, then all of it was. So the jury here found some of the damage was not due to hurricane winds. Therefore, the jury's instructions were wrong as to what they should have been allowed to decide. In reality, this case is quite similar to this court's holding in the Martinez decision in 2015, where that policy did also have anti-concurrent causation language. And I should note, in Martinez, we were dealing with the exact same water damage exclusionary endorsement as we were dealing with in this case. The only difference was it was a different subpart that dealt with rain and groundwater pressure that pushed the pool up from the ground as opposed to windswept rain. I filed with this court after the briefing because it just came out 3 weeks ago, an even more closely analogous case just decided by the 3rd District. That case is more closely analogous because it involved Security First in the case of Zelnuzniak, a decision in late May of 2020. Zelnuzniak correctly relied on your Honor's decisions in Martinez. And to be clear, in that case, we were dealing with the exact same policy language in the Security First policy for an October 2016 loss in Zelnuzniak. And in this case, we're dealing with another October 2016 loss with the exact same water damage exclusionary endorsement, same water penetration language in Zelnuzniak as here, requiring a covered peril to cause a hole in the building through which the rain then caused the claimed damage as the only possible basis of coverage.
Mr. Schwartz, let me ask you a question.
Certainly.
Let's assume you're correct that the jury instruction was incorrect and should not have been given in the form it was. How do you respond to the appellee's suggestion that the jury instruction, or the jury verdict form, which was very detailed, cured any error because the jury, made findings that would be consistent with an anti-concurrent clause having been given?
It's our position that the verdict form simply amplified the mistake. The verdict form, as it was set up, asked the wrong threshold questions on coverage because it had the effect of reading out of the insurance policy the anti-concurrent language. It should have asked the jury, was all of the claimed damage caused by a wind-created opening in the structure, whether the roof, walls, or the windows? And when it failed to do that, it opened the door to the jury coming up with an inconsistent result, finding some of the damage was, at least in terms of how the exclusion is written, excluded, yet some of the damage might have been covered. That's the essence of why the anti-concurrent language was ignored. We would suggest that the verdict form didn't cure the problem at all. In this instance, the way in which the jury was presented the questions overlooked its threshold obligation to render some finding that all of the claimed damage was due to the covered peril opening in the structure. That didn't happen here. As a matter of fact, the jury found the opposite. The jury found some of the damage was necessarily caused by things that are not covered by the policy. That's why it should have never been asked the next series of questions. Well, forgetting the anti-concurrent language that excludes the entire loss, well, how much of the loss do you think might have been covered? That was the error. Now, we suggest that there is a second reason to direct a new trial here that is distinct from the mistakes made in the jury instructions as to causation, and that is that the verdict necessarily shows a compromise both as to liability or coverage in this instance and the damages award. It reflects a compromise on both issues. In this instance, not only did the jury end up compromising the concurrent causation questions, it compromised the amount of the verdict in several ways. There was no evidence of either side that allowed for some math of liquidated amounts. This is a property claim. We're not dealing with pain and suffering, ephemeral damage. These are very specific dollars to fix portions of the house. None of the math by any witness was offered that allowed the jury to take an $80,000 number, discount it by about 40%, and then discount it some more by its offsets. There was no evidence that either the roof or the interior structural repairs, no matter how you looked at the cause of those damages, might have come up with to support this jury amount. We asked that the jury verdict be set aside, not simply because of the causation instructions, but because we see evidence of the compromise of their verdict. And there's one telling fact here as to how the jury deliberated. The jury was out about 2.5 to 3 hours, came back in and asked to see an itemized list of damages. Well, that was a non-existent exhibit, so they were sent back to remember their own recollection on damages. What they then ended up doing was deliberating another 1.5 hours, and you see in the verdict answers to various questions. Not only did they compromise whether the loss was covered or not, or what the causes of the loss were, again, not having an anti-concurrent instruction, they then compromised the dollar amounts in a way that doesn't match any of the evidence. We ask that the verdict be set aside, not simply because of bad instructions, but because the jury compromised damages and liability. I'll reserve the rest of my time.
Thank you. Judge Orfinger, Judge Lambert, any questions?
No.
Okay. Mr. Struble?
I may. Good morning.
You can sit down if you want.
I'm comfortable standing if that's okay.
Okay.
All right, thank you, Judge. Good morning, Matthew Struble for the Appellees, Jeffrey and Michelle Martin. What Security First complains of in this case are the jury instructions and the verdict form, which is clear from the record were the jury instructions and verdict form that Security First itself proposed. You can see from the record that the verdict form in this case was line for line Security First's very own verdict form, which I agreed to. Same thing as to the jury instructions. The jury instructions that were adopted by the court were line for line the instructions that were proposed by Security First in this case. The only instruction at all that was added beyond what they submitted themselves was the concurrent cause instruction that we proposed. And they never provided any counter language. They never suggested that an anti-concurrent instruction should be given. They never proposed one whatsoever. All they did was object to the concurrent cause instruction being given at all, which is cruelly long. As we showed in our brief, all of their exclusions do not have anti-concurrent language. Undisputedly, several of them did not have anti-concurrent language. So without a doubt, the court needed to give a concurrent cause instruction in this case. Security First never proposed an alternative one that they asked for. On appeal now, they make issue and say that the jury should have been asked to determine questions related to anti-concurrent cause. They never proposed a single question to be issued. In fact, and as we make in our brief, they never even pled anti-concurrent cause as an affirmative defense. If you look at their affirmative defenses in this case, which are at 31 through 35, the only anti-concurrent provision that they pled was as to the exclusion related to neglect. And as you can see from the trial transcript at the charge conference, they withdrew that claim for the exclusion for neglect. So looking by their very own affirmative defenses that they filed, they only pled anti-concurrent language as to neglect, defense that they withdrew. So they waived all the arguments that they make in their brief by never even asserting anti-concurrent cause from the outset of the case. They later on waived it once again. You can see from their pretrial stipulation, all of the issues that they put forth in the pretrial stipulation are exactly what was submitted to the jury. And they were submitted to the jury by way of their very own jury instructions and by way of their very own verdict form. So they waived every issue on multiple accounts. In addition to that, even if they were to get past waiver, the arguments that they're attempting to make have no application to a hurricane claim. This court's decision, Liberty Mutual versus Martinez, involved water damage to a pool. The case out of the third that they're referencing, importantly, that involved Security First insurance policy, did not involve a hurricane claim. If you look at the water damage exclusion that they're relying on, the provision goes on to read at the bottom of it that it specifically provides coverage for water damage resulting from damage caused by a hurricane. That's in the water damage exclusion endorsement. So it's the exact thing that was at issue in this case. That was what was litigated and put on evidence of. And because it was a hurricane claim, the insurance policy provides coverage for interior damage when it's the result of a hurricane case. So while they cite to the Security First versus Zezelnik case, they fail to advise this court that that case only involved mold growth and interior damages only, and did not involve a hurricane case. Unlike this case, which went to the trial involving a hurricane claim, which is specifically covered under the insurance policy, and included a multitude of damages, including exterior damages. In the Jeselnik case, as is clear from the opinion, the exterior damages were not even at issue. So you have to look at the actual, and because of that, if you read the Jeselnik opinion, they cited the policy only through subparagraph 6, never went on to the subsequent paragraph, which specifically states that if you have damage directly resulting from a hurricane, then it is covered. And that's exactly what was litigated in this case and presented to the jury. And the jury considered the evidence from multiple experts and ultimately determined that the arrived at the damages based on the jury instructions and verdict form that was provided by Security First itself. Even on appeal, Security First hasn't identified what question they would have wanted to been submitted to the jury. They haven't attempted to fashion a jury question or verdict question as to how they wanted the anti-concurrent language to be presented to the jury. They didn't plead it, and they have still, as of today, have not told this court how it should have been presented to the jury. And case law is very clear that in order to preserve such an issue for appeal, they have to submit a written proposed instruction for the court to consider. They never did that, and that's clear from the charge conference in this case. Because of that, they go on to attempt to speculate as to what the jury in this case determined. And in their brief, they reference a deduction for $4,770 that was made by the jury. They speculate that somehow amounts to the jury reaching a compromised verdict. However, if you're going to speculate, then you can quickly look at the testimony in this case. And we had an estimating expert. An estimate can't be submitted into evidence itself, but the expert went through and testified in detail, line by line, for each area of damage that she included and the corresponding repairs. As an example, in the garage, she testified that the amount included for the garage was $4,770. If you look at Security First testimony, the only pre-existing damage they could offer anywhere was in one area above the garage, in the roof above the garage. So clearly, the jury could have found that the one area on the roof of the garage was what resulted in the $4,770 for the garage, which is the amount that they reduced. And there's a plethora of ways that the jury could have found the evidence that they did. It was supported by a substantial amount of evidence, including multiple experts, and that includes an estimating expert whose testimony went through at trial and provided a room-by-room explanation for damages to be awarded in this case. So when you look at what the standard is as to that, it's whether it was supported by substantial and competent evidence. In this case, it was supported by a expert and engineer who's also a general contractor who testified as to the scope of repairs that needed to be done at the property, as well as the amount of repairs which were given in evidence from an independent adjuster and estimating expert who testified as to those damages in detail. So clearly there was sufficient evidence for the jury to award the amount of damages that it did. So in this case, if you look at the jury instructions that were submitted by Security First, at that time they took the position all the way through that the jury should determine what portion of the damages were excluded. If you look through the burdens on the verdict form, it was appropriate. We were first asked to prove that the damage occurred during the policy period, and then went on to exclusions, and then went on for the jury to determine the amount was excluded. In fact, if you look at the instructions, it gave the Security First several opportunities to prove that the entire claim was excluded if they actually had evidence of it. If they could have shown how shingles on the roof were blown off after Hurricane Matthew, how that was somehow excluded. And if they proved that, the jury could have awarded no damage, but they did the opposite. And supported by the evidence in this case, which was clear that the property sustained damage from Hurricane Matthew. So because of those issues, including that what they're complaining of now on appeal, they never even addressed at the trial court level. And because the jury instructions, the verdict form, are their very own ones that they proposed at the trial court, we believe that the jury verdict in this case should be affirmed.
All right, thank you.
Thank you.
All right, Mr. Schwartz, rebuttal.
Appley's argument that the water damage exclusion as one of the policy's anti-concurrent causation exclusions was never raised is false. The exclusion was raised in the affirmative defenses in the answer to this lawsuit. I refer to paragraph 22, affirmative defense 9, in the answer that asserts that the water damage exclusion is part of the anti-concurrent exclusions in the policy. In the pretrial stipulation, it was submitted that the anti-concurrent language is one of the triable issues in the case. Security First submitted a trial brief the day of the trial, asserting that plaintiff's concurrent causation language and its proffered instruction was a misstatement of the law when you're dealing with anti-concurrent causation questions. And it argued again to assert anti-concurrent language in the instructions. It argued this again during the charging conference. There was no waiver here. The suggestion that calling a claim a hurricane somehow distinguishes this claim from what was addressed in Martinez, what was addressed in the 3rd District Zelnozniak case, is a distinction without a difference. There is no coverage in this policy for a quote unquote hurricane. There are separate causes of loss that may emanate from a hurricane. And the cause of loss here was wind. Wind is what might be covered under a homeowner policy, whether it comes in the form of a hurricane, a tropical storm, or otherwise. But the issue here was not just whether there was windswept rain, the exact same issue in Zelnozniak in the 3rd District. The issue here is whether the wind event created an opening in the structure through which the rain came, and that opening and that rain through that opening caused that claimed damage. That's what was missing here. Lastly, this suggestion that you can explain away the compromise verdict by saying that one of the witnesses said interior garage damage was worth X is simply a false leap of faith to somehow explain the math that the jury used. The jury didn't isolate garage damage. The jury said some dollar amount should be discounted from all of the claimed roof damage and all of the claimed interior damage. That was its compromise error after it already made yet another compromise, the compromise as to what was covered and what was not. We suggest that the verdict cannot be explained based on the way appellees have just described to the court, based on what's in their answer brief. What is simply missing here is some connecting of the dots between the evidence on the damage, either in terms of what it would cost to fix the roof, or what it would cost to repaint most of the house, or what it might cost to replace the flooring in the house. There was no evidence that supported a damage award, let alone the discount on that award. For those reasons, we suggest the compromise.
At trial, did you provide an alternative jury instruction to the court to read instead of the concurring instruction or concurrent cause instruction provided by the plaintiff?
I wasn't trial counsel, Your Honor, but as best as I can tell from the record, there was an attempt at the charging conference to try to fix the problem after the court had already overruled the insistence that an anti-concurrent causation instruction be given. So counsel did the best they could under the circumstances without being disrespectful to the trial judge.
Not really. Did they have an instruction coming into the trial and say, here, judge, here's our anti-concurrent cause instruction that we want you to read because this is clearly an anti-concurrent cause case? And
I don't believe so, Your Honor.
I mean, wouldn't that be the best route to say, hey, instead of working off a faulty instruction that you're arguing from the plaintiff, saying, judge, look, I'm giving you this option. Here's the correct instruction for this case based on the facts of the case and the language of the exclusion. Please use this one. And we have tailored our verdict form, which you don't seem to contest that your side prepared. We have tailored our verdict form consistent with this instruction that we think is the heart of this entire factual dispute.
I think we still come back to the fact that the court had already overruled the request to give some form of anti-concurrent language.
That's great, but sometimes trial judges, can change their mind in the course of saying, well, this is my gut reaction. And then you say, well, look, here's Martinez. Here's this instruction we're preparing. This is what we do for a living here. Please look at this before you, confirm your overruling, and then off we go. I mean, that's not here. And that seems to be the heart of what Mr. Struble says. And that seems to, it kind of is the whole purpose of giving the judge a chance to correct the error before it comes up to us and say, oh my goodness, this is a terrible result, isn't it?
I can only say I might have personally handled this structurally a bit different, but I will say this as well, that when the charging conference tried to drill down to that issue after the evidence had already come in, the court again rejected any argument for anti-concurrent language but then made it worse by a double negative as to how the language might work.
Well, I agree the instruction's confusing, and I don't know that it's, but in any event, but I mean, isn't this someone analogous to say, well, Judge, you know, we want to submit this evidence in, or we want to have this person testify, and the judge says, no, I'm not going to listen to it. You proffer it, and then we talk about it on appeal if the judge, we decide whether the judge erred in excluding the proffered testimony. I mean, that seems to be the concern here, that, you know, we don't have your instruction, your side, and I appreciate that you were not the trial attorney. We don't have that instruction to say, oh my goodness, that's the judge really should have used that, and he had a mechanism to do that, as opposed to simply saying, I don't like the plaintiff's instruction, you need not to use that, and you need to fix it, but you know, here's not my, I don't have an alternative. I mean, that seems to be the concern of the arguments of Mr. Struble here.
I think there's no question that a rejected jury instruction might have amplified this argument even better. But I will say that the court rejected the request for an anti-concurrent type language, never agreed with the argument of defense counsel, and I think defense counsel simply felt that they were swimming upstream and didn't offer competing language after it had already been rejected. I don't think that is the ultimate test on whether this jury was given the wrong law to decide this case based upon the anti-concurrent policy. Are there any other questions from the panel?
No.
All right, thank you both. We will be in recess then until 10 o'clock
Thank you for your time.
for our next oral argument.